The criminal history of the parties is extremely important in a custody case. Hi, I'm Alycia Kinchloe, the owner of Kinchloe Law, a family law practice based in the Philadelphia area. One of the 16 factors that the court must consider when deciding how to award custody in a case is going to be the criminal history of the parties. The court can also consider the criminal history of individuals in the parties' households. But today we're going to just talk about the criminal history of the parties. Now, you always want to speak with an attorney licensed in your state about the facts specific to your case. Understand that Pennsylvania has different laws from the other 49 states, and so you want to make sure you understand what the rules are that govern where you are. It's also important, I find, to choose an attorney who practices frequently in the particular county that your case is in because they're going to also understand some of those unspoken local rules that are there, and they can sometimes have more familiarity with the particular person, judge or master that's hearing your case. Now, that doesn't mean that you're going to have an undue advantage or that they have some type of sway over the person, but because of their previous experience with the courts, they may understand the way that a particular master or judge wants evidence presented to them. And that's why we're going to talk about that in the context of a criminal case or the criminal history of the parties. So, when it comes to looking at the criminal history, a lot of times in certain counties, the masters can only quote unquote see any type of convictions pending cases that are in the state, so in the state of Pennsylvania. So what that means is that sometimes if there's a federal case or if there were criminal convictions in another state, and in Philadelphia County we're right on the border of Delaware and the state of Delaware and the state of New Jersey. So it's not hard for people to go across state lines, commit an act, get convicted, or move back and forth over the jurisdictions. But if you're not aware of that, and the master or the judge is not aware of that, they may not look for a criminal history that exists outside of Pennsylvania. So if you know because you've been in a relationship with the party before, or you've heard, or maybe since you broke up, that the other party has been arrested or been in jail, but nothing is showing up in Pennsylvania, it may be that the particular charges they had were federal, or they may have been in a different state. So it's important for you to do your homework, do your due diligence, because the other party might not volunteer that they were convicted somewhere else. And if the court doesn't see it automatically, they may just go with the flow. Now, it doesn't mean that someone who has a criminal history is unable to have custody of their child or children, or that their rights are going to be suspended, but it is one of the factors the courts will consider. The court will then basically do a risk of harm assessment if there's a pending charge. Now, if there are previous convictions, the court is also going to look to see whether or not there's a risk, but the focus is also going to be on enumerated offenses. So there are a list of offenses that the courts care, for lack of a better word, care a little bit more about when it comes to children. And we've done a video on this before, but these include rape, assault, murder, things like that that are very serious offenses, but even some little bit less serious offenses like possession of some certain types of drugs, and other types of related offenses. So you want to make sure you take a look at those enumerated offenses, and you want to understand whether or not you have one of those offenses, or the party, or someone in their household. Now, when it comes to filing for custody, and it used to be that when you would go to court in Philadelphia County, for example, you would have to complete a verification of criminal history and uh, criminal history and abuse history form. And basically that says whether or not there has been a protection from abuse order against you or one pending, whether there has been the involvement of DHS or some other child youth services department, and giving you criminal history. So when you do file a complaint for custody, the court requires you to fill out that form. But if you're just a responding party, and the way that things are going now with court, you may not actually have to complete that form, which is an oversight, I think, right now that is somewhat problematic, because if the person doesn't have to complete that form, attesting under penalty of perjury that they do have these criminal convictions, they may never come up. So you want to make sure that if you know about the criminal history, if you know the other party spent time in jail and you're not finding it in your state, you want to make sure that you consult with an attorney about the best way to bring this up and the best way to get proof of that and submit it properly ahead of your hearing, just in case it's contested or the other person denies it. All right. I hope to shed a little bit of light on, I guess, some of the criminal history things that come up, especially when someone doesn't volunteer it, and some of the limitations of the court when it comes to actually finding information about criminal convictions of a party. Make sure you hit subscribe and hit the notification bell so that every time we drop a new video, you get a notification. Again, remember, we're doing one every day of 2021 on custody, divorce, and support. All right, until next time, take care.